السلام عليكم ورحمة الله وبركاته. الحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه ومن تبع هداه ثم أما بعد. Inshallah, we're going to have the new session that will start right now. And we have two speakers, مشايخ فضيلة الدكتور Sheikh Jamal Zarabozo and Fadilat Dr. Sheikh Ali Ahmed. And the topic is domestic violence types and rulings, principles for distinguishing between khul' and imposing divorce on account of harm. So each speaker will have 20 minutes, and then we will have a short presentation from one of the sponsors, and then we will open the session for Q&A, inshallah. And we will start with Fadilat Dr. Jamal Zarabozo, domestic violence types and rulings.
بالعربي ما يكون في ترجمة للعربي. لو نعلن بالعربي مش في ترجمة للعربي.
أوكي. راح يكون فيه ترجمة للعربي للذين لا يتحدثون إلا اللغة العربية. بارك الله فيك.
Translating to Arabic for those who can speak Arabic.
Yeah.
I'm pretty sure that's what you just said. الحمد لله والصلاة والسلام على نبينا محمد وأشهد أن لا إله إلا الله وحده لا شريك له وأشهد أن محمدا عبده ورسوله أما بعد. So inshallah, today I've been asked to review three papers related to domestic violence and types of rulings. Inshallah. Grab with my hand. Come on. Okay. So I get one hand here. Okay, inshallah. So inshallah, we have three papers, as I said, and inshallah, two of them I think are in your booklet. One of them is not in your booklet. The first one is called Family Abuse, its Forms and Rulings, Harm in Islam, and Nushuz, focusing on its reality. So the main topic for my 20 minutes, is domestic violence and types and rulings. So the first paper actually is the one that is focused on that, inshallah, so that inshallah most of my attention will be on that paper, inshallah. And alhamdulillah, we have the speaker with us, so inshallah any questions afterwards can be directed towards him, inshallah. So first of all, he talks about family abuse, and he makes the point that from a Sharia perspective, all forms of all forms of abuse, especially family abuse, are going to be prohibited. And obviously, Islam recognizes good treatment or recommends good treatment among everybody as a whole, actually, but especially among family members. So he offers a definition of
المودة والألفة. وهو يقدم تعريفا.
Oh, that's what you're using? Yeah. You don't want to move like this closer to your face instead of over.
they told me to hold it. Okay, all right. So I may not. Let's see how it works, inshallah. That's okay, no, because I might need it for something. Okay, I apologize for that. So he defines, this is his definition that you see there, domestic abuse or family violence. Violence refers to the mistreatment of one person by another with whom they share a close relationship. It is also sometimes referred to as like intimate partner violence, but it also, it's not just the husband and wife, but it extends to, as he mentions here, husband and wife, parents and children, siblings, and he even mentions between a girl and her fiancé. So the type of, so you have like violence, and you have basically harm that can be manifested between different individuals of a household. So he mentions physical harm, which is going to be the most obvious one that people are going to think about. but you also have verbal harm, social harm, economic violence, symbolic violence, and health-related violence. Most of those, I assume, are pretty clear, like how somebody hurts somebody verbally and so forth. But just to give you an example that he gave for economic violence, he talks about, for example, taking a woman's right to inheritance. So many times, obviously, in different societies, obviously the Sharia has allotted a certain portion of inheritance to women, and in many cases they never receive that inheritance. He also mentions like preventing a working woman from getting married in order to control her salary. So the father, for example, make sure that she cannot get married so he still has access to her salary. And he gives other examples of that nature as well. Symbolic violence, he talks about like showing disdain, the father, for example, or the husband showing disdain for the wife, for the children, showing contempt and so forth. And these are all, obviously, these are going to be affecting people on a psychological level, but they're also considered a type of abuse. And I guess also you can use the word violence for it as well. So as he says here, that Islam rejects all forms of violence, and he presents a few verses of the Quran. So all sorts of abuse, all sorts of violence, even in the case of the Prophet ﷺ and his da'wah, as we see in the second verse there, that even with respect to the Prophet ﷺ, Allah subhanahu wa ta'ala made it clear that if he's not like gentle and kind and good in his preaching to the people will automatically turn away from him. So we have plenty of guidance. As I said, he just gives 3 examples, but we have plenty of guidance that shows that basically the default in our relations to others is a peaceful, non-violent, non-abusive type of relationship. So he talks about in the paper physical abuse and violence against children. So as he says here, that actually can start even in the period of pregnancy. So in the period of pregnancy, you can have, for example, abortion, somebody doing something to induce abortion. For example, even like he gives the example of the mother, an example from Imam Ahmed, of the mother trying to take some medicine that will cause abortion. But then there's also like physical violence towards a woman who is pregnant, and as a result of that, causing a miscarriage. And for all of these different cases of causing harm to a person, basically causing death, there's going to be certain punishments. There's, for example, kafara, and there's also something known as al-ghurra, which is basically a financial payment that is special for the case of the fetus. So if somebody, for example, strikes a pregnant woman, so that woman may abort as a result of that, or that woman may actually give birth, and after giving birth, the child might die. So the ruling, if the child is alive after birth, and then it ends up dying, so one of the differences between the two, and he presents the different fiqh madhabs on this. He doesn't necessarily give an independent conclusion at the end, but now you're talking about like what is known as the diya, or the full blood money, as opposed to simply the ghurra. And the point is that obviously any kind of abuse, any kind of violence towards the pregnant woman that's going to cause this harm is basically violence toward the child itself, and it is a prohibited act. He does speak a little bit about what is the ruling of abortion, especially if it is done before the first 120 days. His conclusion is that it should be avoided even in the first 120 days. He also talks about violence towards children after birth, and again, violence towards a pregnant woman is one thing, but then after birth, as he mentions that obviously the Sharia The Sharia principles is we're supposed to raise our children and raise them in a good way and be kind and gentle towards them. He brings this hadith about those who raises 2 girls and how close they'll be with the Prophet ﷺ on the Day of Judgment. He also has a section on elder abuse. And here I quoted a portion from the paper where he says neglect, mistreatment and violence against the elderly in our contemporary world takes various forms: physical, psychological, emotional, financial, and material. And he describes this as one of like the most shameful kind of things. The people we should be respecting, especially from our perspective, the elderly in our community that we should be showing respect to. Unfortunately, they have now become the victims of different types of abuse, and he describes this as like one of the most shameful types of abuse that you can think of. And then he talks about women. So we had abuse of the elderly, and then he talks about women committing abuse towards the members of the family as well as the servants. So the wife committing abuse and violence towards her own husband. And this can take different forms, including like verbal type of abuse, where she continually like belittles the husband, especially like, let's say like in front of others. And he says that some of the reasons behind that is if the let's say like as the woman is married to a very weak person that doesn't like earn her respect, or also could be a result of her bad upbringing, and it could also be the result of when too much of the responsibilities of the family fall on the shoulders of the wife instead of the husband. So especially financial obligations and financial responsibilities. So since this is supposed to be the role of the husband, if the wife is the one undertaking that, this could cause aggression and so forth towards the husband. And then on this point, he actually quotes AMJA. I think it's like 16 points that AMJA has on the question of the responsibility of the men to financially support the household. He also talks about then mothers even abusing their own children. And he says sometimes the abuse coming from the mothers can be actually even worse than that which is coming from from the fathers. The mothers sometimes can be even more aggressive towards their own children than the fathers. And he points out that this might be the result of things like not recognizing the developmental needs of their children, maybe expecting too much of them and so forth, and as a result the mother gets upset and perhaps becomes aggressive. And again, it could be, let's say, like a tarbiyah issue on the part of the mother, that she was not like brought up properly, and these are perhaps the kind of things that she sees. He also talks about women abusing servants as well. He doesn't talk about it very much, but he gives an example of Egyptian actress, I believe, who spent many years, who was sentenced to many years in prison as a result of abusing one of her servants. And then he goes on to discuss some of the causes and the impact of family abuse. So one of the causes, if one of the family members is not treating the other one properly, and in particular if one is banning the others without any like valid reason from a Sharia perspective. Sometimes the husband himself, for example, may have been brought up in a family where family violence was a characteristic of that family that he was brought up in. So he considers it the norm, and this carries over into then the family that he has later. Sometimes it's a matter of also like releasing some of the pressures that people experience in society. Sometimes it could be the result of alcohol and like taking drugs. And obviously in this society, in particular, it's well known how much domestic violence is related to alcohol and so forth. And then he breaks down like the impact that this can have on different members of society. Of the family. The wife, for example, one of the impacts on the wife obviously is in addition to maybe living in a state of fear, but she also might live in a state of guilt, and she might feel that somehow the violence that is going on in the family might be she might be like the cause of it, and so she might feel guilt as a result of that. I guess that's on the next slide there. The effects of violence on children. So one of the things that he mentions here is that, for example, let's say like the girl when she's growing up, if she sees a violent household, she may not be interested, for example, in marriage if she grows up that this is like her picture of what a household is. She may not be interested in living in such an environment. The effects of violence on the elderly. He gives like a number of examples in this case, and you get everything from like physical harm to missing their medications and so forth. And then finally he has recommendations, which he emphasizes. He emphasizes the importance, obviously, of applying the Sharia and understanding the prohibition of committing any kind of wrong towards. There's prohibition of committing dhulm in any case, but obviously prohibition of committing wrong towards any family members and so forth. The last two recommendations that you see there are mentioned. They're not discussed anywhere in the paper, but these are the recommendations, I guess, that he adds here that's going to maybe help people stay away from a situation of physical abuse or abuse in the household. He says spending the night in the marital bed is part of good companionship and fulfilling the rights of the wife. The husband should not abandon spending the night unless there is a legitimate reason. Okay, so basically like abandoning the wife, not keeping this bond of basically going to bed together and so forth. So he's recommending that this is part of keeping good ties between the husband and the wife. And then lastly, he says neither spouse is permitted to have any of their relatives live in the marital home, even if they are responsible for financially supporting them, unless both agree and consult with each other to maintain their right to privacy in their home. Again, as I said, he did not mention this earlier, but this might be based on years of experience where bringing other family members into the actual private household, it definitely, and I can tell from my experience with many couples, it is definitely can be a source of great difficulties, and basically just making the whole marriage situation even more difficult. What does this red light mean? If I don't, 30 seconds? Oh, mashallah. I would say that there is a big question looming over this paper. The Sheikh is here maybe to address it. So one of the sections that he did not mention, or there is not a section there, is basically violence of the husband towards the wife. That was not explicitly mentioned as a section, and that is one of the most common forms, obviously, of marital violence. And in particular, addressing in contemporary times, addressing these kinds of issues, I think, is very important, especially in the light of the Surah Nisa, verse 34. And also in particular, given the fact that there's one madhab, that at least there's one opinion in this madhab that states that as long as the husband, for example, does not kill the wife, there's not going to be any retribution against the husband towards anything that he does towards his wife. So these are, I think, are important questions that need to be dealt with and addressed directly. So the other two papers do not discuss too much on this particular issue, so inshallah I can wrap them up quickly. Dr. Tasneem's paper is more about harm, but of course harm, obviously any kind of abuse and any kind of violence is a form of harm. And the essential point of her paper is that when you look in the different madhabs, all the madhabs are going to agree that there are certain forms of harm or abuse or darar, harm in particular is what her paper is about, that take place with respect to the wife, and remedies are needed for it. They differ, the different madhabs differ on exactly how to identify that darar. As she points out, the Maliki madhab in particular is perhaps the most comprehensive in like accepting or understanding like different types of, let's say, like emotional abuse as a kind of darar. Anyway, in general, they are more open to the idea that the woman has been harmed in different ways, either psychologically or otherwise, in ways, and therefore leading to remedies in ways which are much greater and different than what you'll find in the other madhab. In particular, like in her dissertation, she's focusing more on comparing the Hanafi vis-a-vis the Malikis. And then the last paper, which is my paper, which is not also focusing on domestic violence, but the important thing a couple of important things is, sometimes you'll find actually papers where they talk about the relationship between domestic violence and religiosity. Like, for example, and it's not just with respect to Muslims, like with respect to Christians and Jews, there's like a relationship, they claim, between abuse and religiosity. That basically you have like patriarchal, I guess, misogynistic religions, and as a result of that, you get family violence. First of all, and I just put this in a footnote. Family violence is not necessarily related to toxic masculinity or misogyny. There's plenty of what they call intimate partner violence between lesbian couples, for example. There's been more than one book written about it. So it's not just necessarily a male kind of thing that, as I said, it's not just the result of what they call toxic masculinity. And another point that obviously if, number one, identifying exactly what is nushuz, and then following the correct steps related to nushuz. Obviously from Sharia perspective, if something is going to be sanctioned in the Sharia, if something is going to be sanctioned in the Sharia, then by definition, from the Sharia perspective, this is not considered a type of abuse or type of dhulm. But the thing that is sanctioned in the Sharia could be abused and could be misapplied, therefore leading to dhulm. So both understanding what is nushuz and what exactly are the steps that are prescribed for nushuz, this will go a long way, I think, in if it's then actually put into practice, this will go a long way, inshallah, into remedying some of the domestic abuse that we find among Muslim couples. هذا والله أعلم وبارك الله فيكم والسلام عليكم ورحمة الله وبركاته.
جزاك الله خيرا فضيلة الشيخ Jamal. And now, inshallah, we're going to have Fadilat Sheikh Dr. Ali Ahmed presenting for the next 20 minutes, inshallah. Can we put down?
بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على أشرف الأنبياء والمرسلين نبينا محمد وعلى آله وصحبه أجمعين أما بعد السلام عليكم ورحمة الله وبركاته. My dear distinguished Imams, scholars, teachers and students of knowledge, when we look at all of the papers being presented in this conference, we realize how rich our fiqh heritage is, which has provided solutions to many of the problems that the Ummah has faced throughout its history in various fields. And it continues to provide solutions and alternatives to many novel cases that come on a consistent basis. When it comes to marriage, when it comes to divorce, when it comes to marital disputes, dissolution of marriage, and everything connected to it, the classical scholars, they talked about these issues in detail, and they offered varying solutions that were relevant, that were practical, and it was implemented by the judicial systems in their time. Now, it is important for us as Imams, as scholars, as students of knowledge, as academics, as researchers, that we take the text of the Quran and the Sunnah and the interpretation of the scholars, that we understand it fully, completely, thoroughly, and then we try to contextualize the text to see what problems were these scholars trying to solve. What principles were they following? What situation were they taking into consideration? And after having done such contextualization and tadabbur, then we can see how that implementation can work in our context, living as Muslim minorities in the West, making sure that the masalih, the mafasid are taken into consideration, and also very importantly, ensuring that the huquq of Allah and the huquq of the creation are not transgressed. Now, a lot of times we will see some fatawa, some rulings without this tadabbur, because they were able to find some of the aqwal or the sayings of the scholars, and they are trying to see which one will fit the immediate needs of the situation without really taking into consideration the long-term ramification it will potentially have. And I think Dr. Hatim al-Hajj, he wrote about this, and he talked about this in length in this conference right before our presentation, and he talked about the dawabit and when it is permissible to change the rulings based on circumstances, time, and places. I also would like to make a very important distinction, and this distinction is usually overlooked by some people or most people or a lot of people. But I think that it is important to make this distinction because this distinction, it will greatly help us in solving or in dealing with some of the questions and the problems that our communities, they ask us about, and it will help us to avoid creating the long-term problems and the issues that will result as a result of the lack of this distinction. And that distinction is the difference between a fatwa and a qada. Now, I'm not talking about the difference in definition between the two. I'm talking about the fundamental difference between the two. Because if we understand this fundamental difference, then we are able to know whether a fatwa is needed or if an adjudication is required for a particular case. Now, what is fatwa? Fatwa is bayan al-hukm al-shar'i, which is between an individual and their religion. So it's between the person, he has an issue when it comes to tahara, when it comes to, for example, what is the hukm of wiping over the socks, or if I doubt my wudu, should I go ahead and remake my wudu or not? Qada, on the other hand, is bayanul hukm al-shar'i on a matter of dispute between two or more individuals. Now, if a matter concerns two or more individuals, then they are actually in need of a qada and not a fatwa. They are in need of a qada and not a fatwa, and therefore the process and the procedure for a qada must be followed. And we have many verses in the Quran in which Allah subhanahu wa ta'ala, He says, Ya Dawood, inna ja'alnaka khalifatan fahkum bayna an-nasi bil-haq. We also have Allah subhanahu wa ta'ala saying, wa anihkum baynahum bima anzal Allah. And many other verses. Now, for example, if a wife comes and says that my husband has divorced me and I have waited my iddah, am I still married to him? This is a question that I'm sure all of you or most of you receive on a regular basis. Now, it may be very tempting to say that, no, you are no longer his wife, because a person may look at it from a fatwa perspective and then may give a general fatwa and explaining the sharia in a general sense. However, when we look at this closely, this is a qada'i issue and must be dealt with in such a manner, because it could be that he took her back during her iddah period, but she refused. And I had a case like that, where she went to an imam who gave her the fatwa without really interviewing or asking the husband, did ruju take place? Or actually, without even asking her, did ruju take place? But nonetheless, she was referred to me when I did the whole investigation between both of them, that within the iddah period, ruju had actually taken place. What would be the mafasid that would occur if she had gone thinking of herself that she is free from the bondage of marriage from this husband and gone to marry someone else, but in reality she is still the Shar'i wife of her husband? Now, it could also be that no actual explicit divorce took place, and the husband simply said, go to your parents' house. But she thinks that she got divorced, or that he has severe schizophrenia or paranoia, and he divorced her while in that state. And she fails to mention this to the imam. Or when a wife asks whether she is still Islamically married to her husband because he has applied for a civil divorce, that he has applied for a civil divorce, or that he has apostated. Now, first of all, what constitutes apostasy? Who can make such a ruling on an individual that he is out of Islam after taking the mawani' and the dawabit of takfir? Now, we can imagine that without hearing both sides of the matter and without having a qadi making a judgment of kufr on the husband, you can see that such a case and other similar cases cannot be one that a fatwa can solve, but that it needs to be looked at from a qada lens, and the process and the procedure of qada needs to be followed to reach a solution that will ensure the huquq of Allah is protected and the huquq of the creation are preserved. And this is why I wrote this paper from a qada perspective, making sure that minor and minute details are taken into consideration. The definition of certain issues are dealt with from an Islamic qada perspective, such as the issue of domestic violence, which also Sheikh Dr. Jamal Zarabozo also mentioned, making sure that an Islamic qada'i process and procedure and proper ta'ammul, contemplation, is followed in a particular scenario before suggesting something. Now, when I was studying qada and getting trained in the field, extreme precaution was extreme precaution was emphasized extremely, and making sure that we cover all grounds related to a particular case, and that the correct process and procedure was followed. And that was very much emphasized, because and I can't stress this enough, the concept of the huquq of Allah and the huquq of the creation must be preserved. And that's why the scholar said that qada requires contemplation and deep dive. That's why one case will go ahead and take months, whereas one mas'ala that requires the fatwa can go ahead and take a minute. And so when we are able to understand this difference, then we will be able to know how to deal with the cases that we get on a regular basis. So what is a khula' and what is at-tatliq? Now, first of all, talaq is حل قيد النكاح بلفظ الطلاق ونحوه. And this belongs to the husband. This is a process in which the husband, he has that authority to pronounce divorce upon his wife, in which he intends to terminate the marriage. And this is the right of the husband, and it cannot take place unless it is done by him, according to the hadith of the Prophet ﷺ, in which he said, إِنَّمَا الطَّلَاقُ لِمَنْ أَخَذَ بِالسَّاقِ. That talaq is the right of the one who consummates the marriage, or the one, yani the husband. Now khul', it refers to the dissolution of the marriage, which is initiated by the wife, where she offers something as compensation, which can be equal to or less, and in some cases greater than her mahar, to the husband, which he must agree and consent to, utilizing specific legal terminologies. Now, the primary objective of khula' is for the wife to free herself from this marital bond in a manner that will prevent the husband from taking her back without her consent. Now, we know the legitimacy of khula'. It has been widely upheld by the scholars, and it's also established both in the Quran as well as the Sunnah. And we have the famous incident of Thabit ibn Qais, who came to the Prophet ﷺ, or Fatima bint Qais, that came to the Prophet ﷺ and said, O Messenger of Allah, I do not find fault with Thabit in his character or religion, but I will hate to act in an un-Islamic manner after becoming a Muslim. And so the Prophet ﷺ asked her, are you ready to return the garden that he gave to you in mahar back to him? And she said yes. So he ordered Thabit, he said, accept the garden and divorce her once. Now, this is the first known instance or incident of khula' in Islam. Now, based upon this and even other evidences, the scholars, they deduce that a khula' must consist of 5 elements. It has 5 elements. Number 1, al-qabil. Who is al-qabil? Al-qabil is the husband. It means the person who accepts the khula'. The second is al-mujib. Who is that? That is the wife. The third is al-iwad, the value which is given as a compensation in exchange for the khul' to be granted. The fourth is al-mu'awwad. Al-mu'awwad, now in the context of Islamic marriage, it pertains to the right that renders a woman permissible for a man, and her right to be absolved of the obligation and responsibilities of being a wife. And the fifth is as-sigha, the verbal statement that consists of this offer and this proposal. Now, if it does not contain, or if it does not include all of these elements, that it cannot be considered a khula'. Now let me go ahead and give an example where I would like to emphasize the first pillar, which is al-qabil, which is the acceptance of the husband to the terms and the conditions of the khula'. If he does not accept it, then it cannot be called or considered a khula'. Now, it does not mean that the Sharia has not provided other means which the wife can be freed from the bondage of marriage. It does not mean that the Sharia has not other alternatives for the wife to be freed, but it cannot be through a khul' procedure because one of these elements is missing. Now, I've also discussed in the paper and laid down some procedural steps that a quasi-judicial body or a Sharia council can take into consideration in order to facilitate the conclusion of a khul' case successfully, again while preserving the huquq of Allah and the huquq of His creation, and more importantly, or equally importantly, not rushing to make a judgment and making sure that the decision reached will bring about the masalih of both the clients, both in this dunya and the akhirah, and ward off the mafasid from both the clients, both in this dunya and in the akhirah. I cannot overemphasize how many cases that have come to me in appeal where the husband, where the proper process and procedure was not followed, and the husband is still claiming her as his wife, and now she has a very hard time. Her name is ruined in the community. No one wants to go. She cannot get remarried because the husband is still claiming her as his wife. Why? Because an opportunity was not granted to him. His side of the story was not heard. An adequate amount of time was not given for reconciliation, and the list goes on. Now, what is fasq? Now, fasq, it involves the annulment of the marriage contract, completely dissolving it as if it never existed or as if it never occurred. And this can only be executed by a verdict from a qadi and someone acting in the capacity of a qadi. Now, some of the grounds I've mentioned actually in the footnotes. It could be lack of compatibility. It could be apostasy. Now, who is an apostate? Did he or she apostate? It could be religious disparity. It could be, for example, li'an, especially in the case in which the husband is accusing the wife of zina and she is denying it. It could be due to financial inability, where the husband's financial inability to provide maintenance for his wife, and upon the wife's request for annulment of the marriage, the qadi has to go ahead and take these things into consideration. It could be due to defects of physical defects that prevents intimacy between the spouses, or even induces revulsion between the both of them. Now, at-tatliq, this occurs when an Islamic judge or arbitrators or an authority assuming the role of a qadi, such as a Sharia council, such as an Islamic council, they decide or they conclude to dissolve the marriage on specific grounds within the Sharia, such as darar, such as harm. Now, such tatliq or such an imposition of divorce, this is representative of a court-ordered, or it is equivalent of a court dissolution of a marriage, whose objective is safeguarding a spouse from significant harm or hardship. Now, this judicial dissolution, it differs from khul', where in khul' the wife initiates the separation and it is agreed to and given by the husband in exchange for a compensation. Now, a wife may seek tatliq if she says that her husband has subjected her to harm that renders the continuation of their marital life impossible.
Now, such harm, it can include physical violence, it can include verbal abuse, according to some of the scholars, or any type of intolerable mistreatment. But the question that I always ask, and we should always ask, is who is going to determine this? Who is going to go ahead and determine what constitutes darar? And this brings me back to the initial point that I made. The scholars, or we have the text of the Quran and the Hadith and the aqwal of the scholars. We need to understand them thoroughly. Then we need to go ahead and contextualize that. And then we can go ahead and do tatbiq of it. Without this process, then you can see that we may take certain texts outside of its context. We may take certain texts without really understanding it and may apply it in a scenario that will, instead of bringing the intended benefit, which is the removing of harm, it may bring about its mafasid. So we need to understand that who can determine what is darar. And more importantly, if the darar after separation will be equal or significantly higher, will be significantly higher than the darar that she is facing, outside of the marriage. If the darar outside or after the dissolution of marriage, is that going to be more or equal to the darar that she is currently facing? This is something that a qadi or someone acting in the capacity of a qadi needs to go ahead and really do ta'ammul, contemplation, and understand this. Now, in other words, what I'm trying to say is that if her complaint, for example, against her husband is that he is, for example, stingy, and that there are always fights in the house about money, and that's all of their disputes basically in the house and in their marital life. So she's asking for a dissolution of marriage, and the husband is refusing to give her a khula. Now, a question that should always be considered is, will giving her a tatliq solve her dilemma? Will bring about that maslahah that is intended by the Sharia? Or giving her a tatliq will bring about a mafsada or a darar, which is actually worse for her and for her children? So what should be done? What type of an approach, what type of process should we follow? We should, and this is really not emphasized or taken, and that may be because of many different reasons, but reconciliation, mediation, pressure from community leaders within, the community itself or within the family, in order to come up with a solution that will remove the darar that she is currently facing. Because we have a legal maxim, a qaida fiqhiyya, that states greater harm should be avoided by committing a lesser harm. Greater harm should be avoided by committing a lesser harm. Ad-darar al-ashad yuzad bid-darar al-akhaf. And we also have another qaida fiqhiyya, ad-darar la yuzal bimithlihi, that a harm is not repelled by another similar harm. Now, these analysis and these types of comprehension and ta'ammul, it must be done by senior scholars forming a panel of a Sharia council that are acting in the capacity of Islamic judges. Now, if such a Sharia council or panel of scholars, after their due diligence process, they validate her claim based on her evidence or the husband's admission,
and then they conclude that there is no possibility of sustaining this marital relationship, and they cannot or they are unable to mediate a reconciliation between them, then what happens is an irrevocable divorce can be decreed, and this irrevocable divorce is known as at-tatliq, and this is different from at-talaq, because at-talaq, the husband still has the right, if he is still within the number, the amount of talaq that he has given, 2 or less, then talaq, he can take her back without the consent of the wife, whereas at-tatliq and fasq, he cannot take her, or khul', he cannot take her back without his consent. There are other things that I would like to discuss, but unfortunately I am out of time. جزاكم الله خيرا. السلام عليكم ورحمة الله وبركاته.
الحمد لله والصلاة والسلام على سيدنا رسول الله وعلى آله وأصحابه وسلم تسليما كثيرا. اللهم آمين آمين آمين. اللهم كن بنا رؤوفا وكن علينا عطوفا. اللهم إن هذا فقرنا ظاهر بين يديك، وهذه أحوالنا لا تخفى عليك. نطلب منك يا ربنا الوصول إليك، وبك يا ربنا نستدل عليك. اللهم اهدنا بنورك إليك، اللهم اهدنا بنورك إليك، اللهم اهدنا بنورك إليك. اللهم أقمنا بصدق العبودية بين يديك. اللهم علمنا من علمك المكنون، صلنا بحق سر اسمك المصون، واسترنا بسترك الجميل، واجعل تحت هذا الستر ما يرضيك عنا في الدارين يا رب العالمين. اللهم انصر إخواننا المستضعفين في مشارق الأرض ومغاربها. اللهم انصرهم في السودان والصومال والشيشان وأفغانستان والهند وباكستان والروهينجا والروهين وبنغلاديش وميانمار والصين وفلسطين. اللهم انصرهم في لبنان وسوريا والعراق واليمن وجميع ربوع الإسلام. اللهم ارفع الحصار عن إخواننا المستضعفين في فلسطين يا رب العالمين، كن لهم عونا ونصيرا ومؤيدا وظهيرا. اللهم انصرهم نصرا عزيزا مؤزرا يا رب العالمين. وحد كلمتهم وأقم دولتهم وانصرهم بنصرا عزيزا من عندك وحدك يا رب العالمين. الإخوة والأخوات، السلام عليكم ورحمة الله وبركاته. الاضطهاد الأسري، صوره وأحكامه. يعلم الجميع أن الإسلام يحرم جميع أشكال الاضطهاد الأسري أو العنف الأسري، ويشدد على أهمية المعاملة الحسنة بين أفراد الأسرة. وهناك العديد من النصوص القرآنية والأحاديث النبوية التي تؤكد على حقوق وواجبات أفراد الأسرة تجاه بعضهم بعض، منها حقوق الوالدين وحقوق الزوجين وحقوق الأبناء. والنبي صلى الله عليه وسلم يقول: كلكم راع وكل راع مسؤول عن رعيته. الاضطهاد الأسري أو العنف الأسري يقصد به معاملة شخص لشخص تربطه به علاقة وثيقة. قد يكون الزوج والزوجة، وقد يكون القول بين الأبناء بعضهم بعضا، أو الإخوة بعضهم بعضا، أو بين الفتاة وخطيبها وغير ذلك. وله أشكال ومظاهر متعددة، منها الإيذاء البدني physical abuse، وهو قد يكون إذا صاحبه جروح أو كسر أو أضرار بالمعتاد عليه كالصفع على الوجه أو الركل بالقدم أو الحرمان من الطعام والشراب ولو لفترة قصيرة، إيذاء بدني. وقد يكون الإيذاء لفظي verbal abuse، وذلك باستخدام ألفاظ بذيئة أو عبارات سيئة تنال من شرف الإنسان وتحط من كرامته وقدره، أو التهديد بكشف الأستار والمستور. وقد يكون الإيذاء اجتماعي social abuse، وذلك بمنع الزوجة من المنزل لزيارة أهلها، وتقييد حركة الأبناء في حيز مكاني معين يمنعهم من الاختلاط مع أقرانهم. وقد يكون عنف اقتصادي economical abuse، وذلك بالاستيلاء على حق النساء في الميراث، أو منع الفتاة العاملة من الزواج من أجل الراتب ودفعها للاقتراض من البنوك وكذا، أو الاستيلاء على مهر المرأة بدون إذنها وبدون حق. وقد يكون emotional abuse بتوجيه الإهانة أو الازدراء أو الاحتقار حتى ولو بنظرات الوجه. وقد حث الإسلام على نبذ العنف داخل الأسرة بكافة أشكاله، والآيات القرآنية كثيرة في القرآن، منها قول معروف ومغفرة خير من صدقة يتبعها أذى والله غني حليم. تكلمت في البحث عن العنف ضد الأطفال في الأسرة، وقلت العنف ضد الأطفال ينقسم إلى قسمين: عنف ضد الأطفال قبل الولادة، وقد اتفقت كلمة الفقهاء على إسقاط الحمل، على أن إسقاط الحمل بعد نفخ الروح فيه حرام، لا يحل لمسلم أن يفعله لأنه جناية على حي وجبت فيه العقوبة. وقد ذكرت تفصيل العلماء في ذلك، منها قول الإمام أحمد رضي الله عنه في امرأة شربت دواء فأسقطت إذا تعمدت ذلك، قال: فأحب إلي أن تعتق رقبة، وإن سقط حيا ثم مات فالدية على عاقلتها لأبيه، يعني عائلتها لأبو الولد يعني. وقال الإمام أبو الحسن المواردي رحمه الله: وهكذا لو شربت الحامل دواء فأسقطت جنينا ميتا روعي حال الدواء، فإن زعم الأطباء أن مثل هذا الدواء قد يسقط الأجنة ضمنت جنينها، وإن قالوا أن مثل هذا الدواء لا يسقط الأجنة لم تضمن. وذكرت الراجح من أقوال الفقهاء والله أعلم في من تسبب في إسقاط الجنين ميتا وجوب الكفارة مع الغرة. والغرة هو مفهوم فقهي يتعلق بالتعويض عن إسقاط الجنين، يعني الغرة قد يكون عبد أو أمة صغيرة صالحة، والمعروف عن دية الجنين أنها عشر دية الأم والله أعلم. قال الله تعالى: ومن قتل مؤمنا خطأ فتحرير رقبة مؤمنة ودية مسلمة إلى أهله. ووجه الاستدلال في ذلك أن الآية فيها دليل على وجوب الكفارة في من تسبب في إسقاط الجنين ميتا مع الغرة. قال: فدية مسلمة إلى أهله وتحرير رقبة مؤمنة، ولذلك الكفارة مع الغرة. ثم ذكرت حكم موت الجنين بعد انفصاله عن أمه حيا، وقلت في المسألة 4 أقوال. ذهب الحنفية إلى القول بأن الحامل إذا ألقت جنينها حيا ثم مات ففيه دية كاملة لتحقق الجناية على نفس حية. ثم قلت تجب الكفارة أيضا على الجاني لو انفصل الجنين عن أمه ميتا، فالكفارة مندوبة عندهم، كفارة مندوبة عند الأحناف إذا انفصل الجنين عن أمه ميتا، أما إذا انفصل حيا ففيه الجناية كاملة، يعني فيه الكفارة كاملة. ثم ذكرت مذهب المالكية أو رأي المالكية، قالوا إذا كانت الجناية خطأ بأن انفصل الجنين عن أمه حيا ثم مات ففيه الدية إن أقسم أولياؤه أنه مات من فعل الجاني، وإن لم يقسم أولياءه فلا دية ولا غرة، لأن الجنين إذا استهل صارخا فهو من جملة الأحياء. ثم ذكرت بعد ذلك أنه إذا كانت الجناية عمدا فيختلف الحكم باختلاف وسيلة الإجهاض، فإن كانت الجناية بضرب يد أو رجل ففيه الدية قولا واحدا. وعند المالكية لا تجب الكفارة وإنما تستحب الكفارة، لأن مذاهب العلماء مختلفة، فالمالكية يفرقون فيقولون الكفارة مستحبة، أنما غيرهم كالأحناف والحنابلة يقولون واجبة. الشافعية قالوا بوجوب الدية في الجنين إذا انفصل حيا ومات في الحال، أو بقي يتألم إلى أن مات. أما إذا بقى سالما مدة من الزمان غير متألم فلا ضمان على الجاني. والقول الرابع هو قول السادة الحنابلة، قالوا بوجوب الدية في الجنين إذا ألقي حيا بجناية على أمه ثم مات بسبب الجناية. على أي حال يعني هذه أقوال العلماء وهي موجودة في البحث. أما عن إجهاض الجنين أو الجنين المشوه فيجوز، وهذا ما أفتى به المجمع الفقهي التابع لرابطة العالم الإسلامي، قال يجوز إجهاض الجنين المشوه تشويها شديدا بشرط أن يكون ذلك بقرار من لجنة من الأطباء المتخصصين أو المختصين، وأن يكون ذلك قبل مرور 120 يوما من الحمل، يعني قبل بث الروح فيه. ثم تحدثت في البحث عن أنواع العنف ضد الأطفال بعد الولادة، وقلت أن الإسلام فيه يعني تمتاز معاملة الأطفال في الإسلام بالرقة والحنان والشفقة والعناية والتوجيه، ولا تقتصر التربية والتوجيه على حب الأبناء الذكور، ولكن تكون للذكور والإناث، وفي ذلك أحاديث كثيرة يعني. ثم تكلمت عن العنف ضد المسنين، وقلت أن المخجل في حوادث العنف ضد المسنين أنها تتم على أيدي أقرب الناس إليهم، فنجد بعض الأبناء الذين تجردوا من إنسانيتهم يمارسون أنواعا عدة من العنف ضد ذويهم. وكرامة الإنسان لا تتعلق بالجنس ولا بالسن، وهي أشد وجوبا عند كبر سنه، لحديث النبي صلى الله عليه وسلم: ليس منا من لم يرحم صغيرنا ويوقر كبيرنا. ثم تكلمت بعد ذلك عن عنف المرأة ضد أفراد أسرتها، وقلت أن هناك أنواع مختلفة من العنف تمارسه المرأة ضد زوجها، من ذلك العنف البدني، قد تعتدي عليه بالقتل أو بوضع السم في الطعام أو تعمد التشويه أو الإيذاء أو تشويه السمعة وغير ذلك، يعني الله أعلم، أو عدم مشاركته في الفراش كرها له يعني، أو إهمالا، أو التمنع عنه كنوع من الإذلال، وأيضا تأليب الأبناء عليه باختلاق الأكاذيب التي تشوه صورته أمامهم، أو محاولة تدمير معنوياته واتهامه بالفشل ومعايرته إن كان فقيرا. وقلنا أن العوامل المؤدية إلى سلوك المرأة عن طريق العنف ضد زوجها كثيرة. قد يكون الزوج ضعيف الشخصية، وقد تكون المشكلة في النفقة، لأن النفقة من مسؤوليات الزوج. ثم تكلمت عن النفقة يعني قليلا في البحث. والنفقة تجب النفقة للزوج على زوجها بالعقد الصحيح إذا سلمت نفسه إليه، لأن النفقة في الفقه الإسلامي مقابل الاستمتاع. طيب، هي بس يعني في نقطة تبقت إن شاء الله أنا أريد يعني أن أذكرها سريعا. تكلمت أيضا عن القانون، الفرق بين الزواج الطلاق في الشريعة الإسلامية والقانون الأمريكي، هو موجود في البحث. وتكلمت عن الانحرافات الأخلاقية مثل شرب الخمور والمسكرات، قد تكون سببا في تأجيج الخلافات العائلية وتؤدي إلى العنف. وفي نقطة مهمة جدا اللي هي موضوع المسنين ده، بيت المسنين. هل هو يعني احنا عندنا في بلاد المشرق يختلف الأمر عن بلاد المغرب. بيت المسنين في بلاد المشرق قد تكون وصمة عار يعني على جبين الأسرة إن وضعوا أباهم في بيت مسنين، يعني الناس لا تتقبل هذا الأمر ويعتبرون هذا يعني من يعني عار كبير جدا. ازاي تحط ابوك في بيت مسنين؟ هنا في امريكا قد يختلف الامر، الاختلاف في العادات. وهنا في امريكا يعني الزوجة تعمل والزوج يعمل والاولاد في المدارس او يدرسون ولا يوجد احد في البيت، فقد يكون وضع الاب في البيت بدون عائل معه يعني بدون حد معه قد يعرضه هذا للاهمال، وهذا ليس من الإسلام. فقد يكون وضع الأب في بيت المسنين هنا في أمريكا من باب الرعاية، ولذلك ينظر، وهذا رأيي والله أعلم، ينظر فيه إلى المصالح والمفاسد. لو كانت مصلحة الأب أن يكون في بيت يكون عنده ممرضة تديله تناول العلاج من وقت لآخر، ويكون عنده دكتور كل شوية يبص عليه ويتابع معاه، ويكون عنده ناس تجيب له الأكل كل شوية ويكون عنده ناس يتكلم معاهم وأصدقاء، ويروح الجيم في بيت المسنين. كل هذا في بيت المسنين سينيور سيتيزن هاوس. فقد يكون هذا أفضل من أن هو يكون محبوس في البيت لوحده ومعهوش حد، والأبناء يعملون ساعات طويلة، وهذا ليس من البر والله أعلم. فأسأل الله سبحانه وتعالى أن يبارك في الأعمال والأقوال، وأن ينفعنا بما علمنا، وأن يزيدنا علما مع الإخلاص لوجه الكريم. وصلى اللهم وسلم وبارك على سيدنا مولانا محمد وعلى آله وأصحابه وسلم تسليما كثيرا. ما كان من توفيق فمن الله وحده، وما كان من خطأ أو سهو أو زلل فمني ومن الشيطان، والله ورسوله منه براء. وأعوذ بالله أن أذكركم به وأنساه، وجزاكم الله خيرا. والسلام عليكم ورحمة الله وبركاته.
Jazakallahu khairan, Fadilat Sheikh Abdul Hamid Algizawi. And inshallah we have 10 minutes before the break, so we'll take this time for questions and answers. As you know, 2 mics for the shuyukh and 1 mic for our sisters. And of course, we are not going to take all the questions, obviously, but there are going to be another session, just niqash maftuh, an open discussion, starting from 11:30 to 12:30. So whoever will not have the chance to ask the question now, they can have the chance to ask their questions later, inshallah. So let's start. تفضل أخي الكريم.
السلام عليكم، جزاكم الله خيرا. سؤال: في أمريكا يأتي الكثير من الوافدين ومن المهجرين، تأتي معهم عادات من ضمنها ضرب الأولاد، من ضمنها ضرب الزوجة، وقد يجد البعض في التراث الإسلامي يعني فاضربوهن وكذا، يجد تبريرا لذلك. هل يصح لسادتنا المشايخ والخطباء والوعاظ أن بناء على درء المفاسد وتقديم جلب المصالح، كما تعلمون مفسدة أخذ الأولاد من قبل Child Protective Agency مثلا، إذا ضرب الولد في هذا البلد قد يؤخذ منك يعني ويتربى في أسرة نصرانية مثلا، وإذا ضربت الزوجة قد يعني يمنع الزوج من الاقتراب حتى، كما تعلمون هذه الأشياء. فمن هذا الباب هل يصح كما عطل سيدنا عمر رضي الله عنه قطع السارق في الحرب؟ نحن في بلاد يعني كأننا في حرب في هذه المسألة، فهل يصح أن يقال أن مسألة الضرب ينبغي أن تترك تركا نهائيا، وأن يعني تركا لا رجعة فيه لما يترتب عليها من مفاسد؟ جزاكم الله خيرا.
بسم الله الرحمن الرحيم، الحمد لله والصلاة والسلام على رسول الله. لم يقل أحد من أهل العلم إن الضرب ضربة لازم في علاج النشوز، وإنما هو خيار من الخيارات، وكأي تكليف مناطه القدرة ولا تكليف مع العجز. فإذا ترتب على الضرب وهو ليس واجبا وليس مندوبا، النبي صلى الله عليه وسلم قال: ولا تجدون أولئك خياركم. عندما تحدث عن الذين يضربون نساءهم قال: ولا تجدون أولئك خياركم. وما ضرب بيده غلاما ولا خادما ولا امرأة قط، لقد كان لكم في رسول الله أسوة حسنة. فالضرب خيار يصار إليه كآخر الدواء في علاج حالات الشقاق والنشوز بين الزوجين، وليس سبيلا أوحدا، وليس طريقا حتميا، ولا مرغبا فيه، ولا مندوبا إليه، ولا حببت إليه الشريعة، ولا مارسه صاحب الشريعة صلوات ربي وسلامه عليه. والعاقل من عرف زمانه. أحبابي، لا تقطع الأيدي في الغزو، ولا تقام الحدود في أرض العدو. ما هو أبلغ من ضرب الزوجة؟ إقامة الحد. لحد يعمل به في الأرض خير لأهلها من أن يمطروا 40 صباحا. ومع هذا لا تقطع الأيدي في الغزو ولا تقام الحدود في أرض العدو. قالوا: لماذا؟ لكي لا تدرك المحدود حمية الشيطان فيلحق بمعسكر الكفار. إذا كنا متأخرين لأرض العدو وارتكب أحد الناس جناية سرقة وعرف أننا سنقيم عليه الحد، سيقفز إلى المعسكر المقابل ويأخذ لجوء سياسي ويدوه جواز سفر أو جرين كارد، ويعني وقد ينقلب على عقبيه. فالمحافظة عليه بدين منقوص خير من ذهاب أصل دينه بالكلية. والشريعة قائمة على تحقيق خير الخيرين وعلى دفع شر الشرين. نحن لا ننسخ الحكم ابتداء من الشريعة، لكننا نقول إن تطبيقه مرتبط بشروط ومرتبط بما يسمى ببساط الحال. إذا تحققت الشروط وتوفر بساط الحال أمكن النظر إليه، وإلا فإن تجاوزه أولى. وهكذا في كل تكليف ليس واجبا وليس مفروضا، لكنه خيار من الخيارات المشروعة إذا كان سيؤدي إلى مفسدة أكبر لا شك أن تجاوزه أولى وأقيس وأقعد وأصغر، والله تعالى أعلم.
جزاك الله خير شيخنا. تفضل أخي كريم.
جدا.
بسم الله.
بصوتك واملئ الأسماع.
جزاك الله خير سيدي الشيخ، رضي الله عنكم ونفعنا بعلومكم. سيدي الشيخ، السؤال في حالات خاصة هل يجوز للمفتي أن يخرج عن دائرة المذاهب الأربعة نظرا ومصلحة للعائلة حتى لا تضيع؟ مثلا شيخنا نأخذ بقول سعيد بن المسيب في قوله تعالى حتى تنكح زوجا غيره حتى تعقد، وأما حديث العسيلة نحمله والعسل أنواع وأشكال كلنا على حسبه سيدي، فما رأيكم دام فضلكم؟
رضي الله عنك وأرضاك كما دعوت لنا، بارك الله فيك.
أمين أمين أمين.
بالنسبة للمستفتي العامي لا يصح له مذهب ومن أفتاه، مذهبه مذهب من أفتاه. بالنسبة للمفتي المطلوب منه أن يبحث عن حكم الله سبحانه وتعالى وفق ما ترجح لديه إن كان من أهل النظر، حتى لا يهجم على الاجتهاد من ليس للاجتهاد به. يعني لا حرج أن يأخذ بقول شيخ الإسلام ابن تيمية في التفريق بين اليمين وبين الطلاق، القول المبين في الفرق بين الطلاق واليمين. وقد أخذت وثيقة مجمع فقهاء الشريعة بهذا، واعتبرت أن الحالف بالطلاق إذا لم يقصد بحلفه الطلاق بل قصد الحظ أو المنع أو التصديق أو التكذيب أجري قوله مجرى الحلف ويخرج من تبعته عند الحنث بكفارة يمين. وأحد إخواننا أظنه موجود معنا هنا في القاعة، لا نقدم رسالة ماجستير أو رسالة دكتوراه، يعني الفتاوى التي خرجت فيها دار الإفتاء المصرية عن المذاهب الأربعة، وهذا دار إفتاء كبيرة تابعة للأزهر وتابعة لدولة كبيرة، لكن فقهاء اجتهدوا في كثير من المسائل وخرجوا عن مقتضى المذاهب الأربعة، لكن فقهاء عندهم آلية الاجتهاد حتى لا يهجم على الاجتهاد من ليس له به. إن الإسلام كان قبل أن يولد أبو حنيفة، وقبل أن يولد مالك، قبل أن يولد الشافعي. الإسلام أقدم من هؤلاء جميعا. أنت تبحث عن حكم الله عز وجل، والمستفتي إذا اختلفت عليه فتاوى المفتيين مطلوب منه أن يبحث حتى يغلب على ظنه أنه يتبع حكم الله فيما يتابعه من أقوال وآراء قد عرض عليه، فقد يأخذ بقول الأعلم والأورع، وقد يأخذ بقول الجمهور يغلب على ظنه أن قول الجمهور أولى بالصواب وأسعد به من القلة المفارقة، وقد يعمل بالاحتياط. المقصود لا حرج فيما تقول إذا كان الناظر في هذا من أهل النظر وأهل الاجتهاد.
جزاكم الله خير سيدي الشيخ. هناك أيضا سؤال من الشيخ المترجم، فهل أقدم المترجم على سؤال الشيخ؟
جزاك الله خير. It's 11:15. It's time to take the break for 15 minutes, and there will be an open discussion, نقاش مفتوح, starting from 11:30 to 12:30. So all the questions that didn't have the time to be asked, inshallah, you can ask them during the open conversation. جزاكم الله خير. بارك الله فيكم. حفظكم الله. السلام عليكم ورحمة الله.
أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. والصلاة والسلام على أشرف المرسلين وبعد. Praise be to Allah the Merciful, and peace be upon Prophet Muhammad sallallahu alayhi wa sallam. Welcome back everyone. We ask Allah subhanahu wa ta'ala to accept from all of us and make us of those who practice the knowledge we learn from those beautiful sessions. And this is the time for an open discussion. If you have a question from the previous sessions, you're welcome to come and ask the question. Only 1 minute asking the question. Summarize the question, and inshallah we will work with you. Jazakumullahu khairan. And you can identify the sheikh, the scholar. You want him to answer your question, that's up to you. If not, then alhamdulillah, we have our shuyukh, they all able and capable, mashallah, to answer your question. We will start, inshallah, from Dr. Bassam. You have a question, and then we will go, Basim, Dr. Basim. And then we go to the sister, and then we go to the brother. We didn't start from here because this is from like previous, please forgive me. جزاكم الله خيرا دكتور باسم.
السلام عليكم. السؤال موجه لفضيلة الشيخ صلاح. تطرقتم البارحة لمسألة اللجوء إلى القضاء المدني إذا تعين وسيلة لحماية الحق الشرعي، ولعل هذه النقطة تم يعني إساءة فهمها وورد سؤال بهذه الشأن حتى أنه تشجيع إلى اللجوء للقضاء المدني، فأرجو توضيح هذه المسألة حتى تنجلي الأفهام في الأذهان. جزاكم الله خيرا.
إن شاء الله. بسم الله، الحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه ومن والاه. أما بعد، فإن الذي ندين الله تعالى به أن الحجة القاطعة والحكم الأعلى هو الشرع وحده، وأن الحكم بغير ما أنزل الله من المحرمات القطعية في الشريعة، وهو سبيل إلى الكفر والظلم والفسق بلا نزاع. الأصل هو وجوب التحاكم إلى الشرع المطهر داخل ديار الإسلام وخارجها، فإن أحكام الشريعة تخاطب المسلم حيثما كان، وتحكيم الشريعة عند القدرة أحد معاقد التفرقة بين الإيمان والنفاق. إذا لم يكن سبيل إلى التحكيم الشرعي الملزم على مستوى الدول والحكومات، فإن هذا لا يسقط وجوب تطبيقها وتحكيمها على مستوى الأفراد والجماعات، فإن الميسور لا يسقط بالمعسور. وفي التحكيم والصلح ونحوه بدائل عن اللجوء إلى التحاكم إلى القضاء الوضعي القائم على خلاف الشريعة. ثم بعد هذا قلنا يرخص، وركز على كلمة يرخص، في اللجوء إلى القضاء الوضعي عند انعدام البديل الشرعي القادر على رد الحقوق واستخلاص المظالم. يرخص رخصة على خلاف الأصل في اللجوء إلى القضاء الوضعي عند انعدام البديل الشرعي القادر على استخلاص الحقوق ودفع المظالم، وهذا مقيد بقيود. أولها تعذر استخلاص الحقوق من خلال الطرق الشرعية، تحكيم الصلح، اللجوء إلى المسجد، يعني إذا تقطعت به الأسباب وغلقت دونه الأبواب ولم يجد أمامه من سبيل لاستخلاص حقه أو دفع الظلم الواقع عليه إلا هذا. كواحد هجمت عليه يعني لص أو قطع طريق، اتصل بالشرطة، فالاتصال بالشرطة لا يقال أنه تحاكم إلى القضاء الوضعي واللجوء إلى النظام المدني، هذا لدفع مظلمة، لدرء حرابة، لكف عدوان. مثله أيضا الزوج الذي امتنع عن النفقة على زوجه وعلى ولده، وحاول المسجد معه فعجز، وأصر وأبى واستكبر استكبارا، فلم يكن من سبيل إلى استخلاص حق هذه المظلومة المهجورة إلا من خلال اللجوء إلى المحكمة المدنية لإجباره على إنفاذ حق شرعي وعلى إنفاذ حكم شرعي. وقد قلنا وأكدنا استعداء سلطان القضاء الوضعي لإنفاذ الحكم الشرعي لحماية الحق الشرعي. أكرر وأؤكد، نحن أمام حالة استعداء سلطان القضاء الوضعي لحماية الحق الشرعي وإنفاذه. عندما يتعين وسيلة وحيدة لاستخلاص حق أو دفع مظلمة، وذكرنا أيضا لابد أن يلجأ قبلها إلى حملة الشريعة وأهل العلم لكي يقرروا لهم ما هو حكم الله في هذه المسألة، لتقتصر مطالبته أمام القضاء على هذا الحق وفي هذه الحدود المشروعة لا غير. بل ذكرنا ينبغي أن يلقى بقلبه اللجوء إلى القضاء الوضعي، وأن يعلم أنه ما ألجأه إلى ذلك إلا الاضطرار والاقتهار وحالة استثنائية مر بها. ففي هذا الإطار كان حديثنا، وينبغي أن يفهم كلامنا. بارك الله فيكم.
جزاكم الله خيرا شيخنا، نفع الله بكم، تقبل الله منكم.
آمين.
السؤال للأخوات إن شاء الله.
Assalamu alaikum warahmatullahi wabarakatuh. So my first question is that if the woman is dependent on her spouse, then in the case of divorce, who is required to pay the lawyer's fees, and what would it come under, a Sharia ruling? And then would it be subtracted from, the nafaqah or the mahar when it is paid to the wife? The second question is, as Texas is community property state, and if there's no prenuptial agreement, but during the lifetime the husband says, he agrees that, okay, half of my property is yours, then would there be an issue in accepting the civil distribution? The third question is, when does the woman's iddah begin? When the husband applies for the divorce with the intention, the question is based on he has a serious intention of divorcing, it's for no other reason. So when that happens, or when she applies for a khul and then he accepts it, the second part of that is, what if it takes some time to do the discovery process and distribute all the property? So how would that relate to the iddah period? Because when would the divorce be? Because the divorce will officially be finalized in civil court later. So the woman is, when is she supposed to start counting?
Jazakallahu khairan, my dear sister. Barakallahu fiki.
So I got the first and the second, but I didn't get the third question. And I think the first... I got the first and the second, and I didn't get the third question. But the first question is about, the fees for the lawyers in divorce disputes. So that's certainly not part of the nafaqah. That's wajib on the husband if she's taken him to court. And the idea here is that we have three levels, as Sheikh Salah mentioned yesterday. We have at-taradi, at-tahkim, at-taqadi lil-qada al-wadi. And we don't skip one level to the next without exhausting all possible means to utilize that level. So the first level is at-taradi, which is mutual agreement between the two parties. And we want all divorces. We don't want any divorces, but when divorce must happen, we want all divorces to be settled through taradi, mutual agreement. And they can do this on their own, or they can do this with the assistance of family members and wise friends and the imam of the masjid or whatever. Then, if that fails, then we go to tahkim al-shar'i, and we go to a sort of Islamic arbitration, Islamic mediation, to adjudicate these cases. And I'm extremely pleased by the spread of arbitration committees in all cities. There is an arbitration committee in the city. They have a booth outside. There's probably more than one. I just visited one booth. I would be glad to visit others. But I am extremely glad that there are arbitration committees, because we cannot afford to be as encyclopedic as our great scholars of the past. So when we zoom in on one particular area of the law, and we have comprehensive knowledge in that particular area of the law, then that certainly would be conducive to more tawfiq in terms of our mediation or arbitration. So in these cases, the fees will be not that huge or burdensome for either party. And then if one of them insists, if one of them refuses the tahkim of al-shara and insists to take the other part, insists to, to reject the tahkim of the shara, the other party is then entitled to take them to court for enforcement, because we don't have any executive power as Muslim arbitrators in this country. So in this case, if the husband, for instance, refused, and it did cost the wife a lot of money to take him to court because he refused the Shara'i tahkim, and then he agreed to the Shara'i tahkim, the Shara'i arbitrator will take that in consideration when he basically settles the financial matters between them. He will take that in consideration, that this man was defiant to the Sharia, forced his wife to take him to court, cost his wife so much money to do that, and then we will basically factor this into our final settlement as arbitrators. So that's the answer to the first question. The answer to the second question? The second question.
There was a community property.
What was it?
The community property.
Huh?
Community property.
Okay, so if he agrees to give her half of his wealth, and this is the agreement between them, the power of this agreement depends on the nature of this agreement. Is it a shart that is a prenuptial condition, or is it such an agreement that he told her one day that you will have half of my assets? And in this case, keep in mind that hadiyya is not enforceable until acceptance and basically possession also. So you can't only say that the hadiyya has become enforceable according to the majority position also of the hadiyya, not merely acceptance of the hadiyya would be required for the hadiyya to be enforceable or to be final. In this case, what we say is make it a munajjaz hadiyya. I mean, don't just promise to give half, ask for hadiyya munajjaza, which means immediately effective hadiyya. So every once in a while, they basically, and it doesn't have to be half and half, because if the sisters ask for half, then the sisters will need to also be responsible for half of the obligations. That is just common sense. If you ask for half of the entitlements, you need to be responsible for half of the obligations. But whatever it is that they will agree on in terms of the division of wealth, make this munajjaz, make this immediately effective, and transfer ownership, because if someone promises and takes the promise back, you can't enforce it on them.
جزاك الله خيرا. إن شاء الله أحبابي، بس بين قوسين، أنا جاءني استفتاء حول مناصفة المرأة لزوجها لمالها عند الطلاق، لكن أنا جاءني الاستفتاء بطريقة منظمة جدا، ما كنت أحسب أن امرأة تبلغ في عرض سؤالها هذا المبلغ. فأحببت إن شاء الله أن أجد 5 دقائق في هذا السيشن، في بدايته، في منتصفه، في آخره، لأعرض عليكم ماذا قالت وماذا قلت، لكن في الوقت الذي ترونه مناسبا إن شاء الله.
Inshallah, the end of this session, we gave 5 minutes or more to Dr. Salah to elaborate on the point that he just mentioned. And now the third question, inshallah, if we have time, then we will answer it. If not, then good luck meeting with Sheikh Hatim, inshallah, and he will answer it for you.
Assalamu alaikum. Ahsanallahu alaikum. My question is about the khul'a that was mentioned earlier, that the husband's permission is necessary. What if the wife follows a different madhab? Jazakumullah khairan.
The husband's permission for khul'a is necessary according to the 4 madhahib. However, there is a position that the husband's position. Keep in mind, khula is different from when you have the hakamain, when you have the arbitrators adjudicate the disagreement or the dispute between the two spouses. Khula per se, the husband's permission is required for khula to be effective. However, Imam Ibn Taymiyyah said it is wajib on the husband to grant her khula when she asks for it, and this is a riwayah in the madhab, and this is a position of many of the scholars from before, based on the hadith, Imra'at Thabit ibn Qais, which is clearly talking about خُذْ حَدِيقَتَكْ وَطَلِّقْهَا تَطْلِيقًا. Take your garden back, or take your orchard back, and give her tatliqa. This is an amr from the Prophet sallallahu alaihi wasallam. Is this the amr from the Prophet in the capacity of his prophetic position, or as a qadi? That's a point of contention here. But there is a position that makes khula wajib, obligatory on the husband when the wife asks for it, and that position has been chosen by several Muslim countries. They grant her khula, they force it on the husband. Now, this is just khula per se, but if you say that she's asking for khula, and then we defer the matter to the hakamain and the judge, do the two arbitrators or to the adjudicators, whatever, the hakaman, do they have the right to issue divorce, to grant her that khula or that separation, or to issue divorce, or they don't have that right? Here the discussion will be different, because it is a position of a mu'tamad position of one of the four madhahib. That's the Maliki madhab, and a riwayah in the Hanbali madhab that was chosen by Imam Ibn Taymiyyah as well, that they will have the power to separate between them. The hakaman will have the power to separate between them. Now the hakaman are basically expected to reconcile, and I was talking to the brothers outside that we should not rush to separating between married people, and arbitrators should use counselors, and I spoke with several counselors today. That's another important service. Arbitrators should offer to refer them to counselors before they address the issue from its legal angle. Let us not destroy the Muslim family. Let us not rush to divorce. Divorce is devastating, particularly if children are involved. So the arbitrators will advise them, or require them in certain cases, if they believe that it is warranted, to go to counselors, and those counselors who are also straddling the two fields, psychology and Islam, will do their best, and if they fail, they come back to the arbitrators. The arbitrators, according to the Maliki madhab and a position in the Hanbali madhab chosen by Imam Taymiyyah, do have the power to separate between them without the permission of the husband.
تصحيحا لمعلومة شائعة مغلوطة أحبابي، المرأة لا تملك أن تخلع نفسها، لأن هناك من يتصور أن المرأة إذا غضبت من زوجها وبطرت معيشتها وكرهته تحط له الفلوس بتاعته في المسجد، أو تحط له على الجزمة وتقول له أنا كده خلاص، أنا كده خلعت نفسي. المرأة لا تملك أن تخلع نفسها، تملك أن تلتمس الخلع، والخلع إنما الطلاق لمن أخذ بالساق بيد الزوج. إن أمسك زوجته ضرارا وأبى، هنا يتدخل القاضي لإنصاف المظلوم وللضرب على يد الظالم. الخلع تملك المرأة أن تلتمسه، ولا تملك أن تفرضه.
جزاكم الله خير.
So she had a question as to, is her iddah started and finished, or is she supposed to start her iddah after the paperwork, like the legal divorce is done? And if her iddah is finished, is she allowed to start receiving other proposals from marriage?
جزاكم الله خير.
Bismillah ar-Rahman ar-Rahim. So if I understand your question, you're saying that the husband sent a note saying that you are divorced.
He sent the paper divorce with a lawyer.
He applied for the civil divorce and he sent the papers
Yes.
to him. So what is the question?
He never pronounced divorce
Yeah.
with his mouth to her, to tell her
Yeah.
she was divorced. And the legal process has been going on for over a year. So is she divorced already? Is her idda done, or she's still not divorced?
So I think like what Sheikh Salah Sawi said with regards to this particular issue, I think it's important that an adjudicator or an arbitrator or an imam hears what the husband. There could be many intentions behind this. It could be that he is also Islamically divorcing his wife. It could be that he is trying to save his wife from financial bankruptcy. It could be many different reasons. In order to get an absolute answer, the imam, the adjudicator, would have to call the husband and ask him what was the reason behind him applying for a civil divorce. Was his intent also to enforce or to effect the Islamic divorce? And if the imam hears his side, then he will be in a better position to make that judgment. Otherwise, if we were to give a very generic fatwa, then you can imagine everyone is going to apply it in their own circumstances in a way that they see fit, and that can create a lot of confusion amongst many people. Allah knows best.
I just wanted to add that also according to AMJA, the verbal pronouncement of divorce is not the only way to make a divorce effective. If the husband willingly signs divorce papers, كتابة الطلاق من كنايات الطلاق, which means when you write divorce or sign the divorce paper, this is one of كنايات الطلاق. It's dependent on the husband's intention. Therefore, if he was coerced into it, then we need to investigate that, and certainly if he was coerced into it, then it will not be effective. But if he willingly does it, then according to the AMJA family code, it will be effective. It will be effective like the verbal pronouncement.
Can I make a clarification? And then the idda will start counting from the time he signs
From the time
papers?
it has been effective, from the time it has been effective, either by verbal pronouncement or signing divorce papers without coercion.
Okay.
Like willingly writing the divorce.
جزاكم الله خيرا.
جزاكم الله خيرا. My dear brother, please.
السلام عليكم يا مشايخ الفضلاء، جزاكم الله خيرا. هذا السؤال خاصة للشيخ دكتور علي. Dr. Ali, it's known that there's a lot of marriage problems in the Muslim community, and it's also known that there is a lot of discord and fighting, يعني للأسف, amongst AMJA and students of knowledge. So in the event that in a state or in a locality, in a community, there cannot be a Sharia council formed, would you advise that an imam in a community center or Islamic center single-handedly take the position of an Islamic arbitrator or the Islamic judge? That's question number one. And question number two, whether the individual imam or a Sharia council passes the hukm of tatliq, what gives legitimacy to their claim? This was already answered a little bit by Fadilat al-Sheikh, but we would like to hear your answer to. Jazakallahu khair.
To be honest, I think this the wisdom that Sheikh Salah Sawi that we can all learn from, I think it will be more respectful if we can have Sheikh Salah Sawi answer this question. But he has given me permission, so may Allah bless him. With regards to one individual imam or scholar doing a tatliq, which is the imposition of divorce upon the wife, despite the agreement of the husband. This is my opinion, that it is not permissible for one individual, no one individual scholar has the authority to go ahead and impose the talaq on a wife. Any matters that concerns the ummah, anything that concerns more than just one individual, it has to be done collectively, it has to be done in collaboration with the other ai', whether in the city or in the state or in the country. Anything that affects the community, anything that affects the ummah, no one scholar has the authority to make such a binding or a lasting decision. And that's why it is highly, I don't want to say wajib, but I would say highly recommended that such decisions should be taken up by a panel of scholars. And this is also for the protection, both dini and dunyawi, of the imam. So that way it does not come back to harm him. Why? Because now this is taken as a collective panel. And also when things, such decisions are taken in a shura, in a panel, then the likelihood of miscarriage of justice is lessened, as opposed to one individual who does a tatliq. Now, where does a scholar or a panel or a Sharia council get their legitimacy, their authority? The scholars, they talked about this from all the four madhahib. The Malikis were the first one to talk about this, and they came with the qa'ida that ahlul halli wal aqd, the scholars and the community leaders, they will go ahead and assume the role of the leader and his deputies when there is none. And also the Hanafis and the Hanbalis, they said يقوم جماعة المسلمين مقام القاضي ونائبه. Now, how does a judge, an Islamic judge, gets his authority? An Islamic judge gets his authority through Waliul Amr. Where does Waliul Amr get his authority? By the masses, by the people selecting him as Waliul Amr. Likewise, when we do qiyas in our context as Muslim minorities living in the West, a Sharia council gets their authority through the Muslim community that they serve, who will look at them to solve their everyday needs and their challenges. And in addition to that, recognition by the senior scholars. Recognition by the senior scholars who have said that these people or this group of scholars are in a position, both from a theoretical as well as from a practical perspective, that they have the necessary knowledge and the know-how how to dissolve or how to bring about reconciliation or a conclusion to a particular marriage. So the authority of a Sharia council comes from not only the community, but as well as the senior scholars that we have in America. And this is why it is highly advisable that this collaboration and this ta'awun is made with the likes of AMJA and the senior scholars of AMJA, and presented to them. Presented to them is your process and your procedure and how you're going to adjudicate such cases, so that way you will be more effective. The last thing you want to do is to give a ruling which the husband will reject and claim his wife as his wife, whereas she has acted upon your judgment, and she goes and she wants to get married to someone else, and then her life is ruined with the second individual, and you can imagine the mafsada that occurs due to that.
Jazakumullahu khairan.
I just have a clarification from my last answer. I wanted to say that I said that kitabat al-talaq min kinayat al-talaq, therefore it's contingent on the niyyah. That kitabat al-talaq is not explicit, but it is implicit divorce. It's contingent on the niyyah of the husband. So my answer is within the context that was that was said, which is a husband who abandoned his wife for a couple of years and then sent her the divorce papers. If we're talking about a different context, when a husband tells his wife that I will divorce you in court for whatever reason, but it's not, I don't mean to divorce you or something like this, then it's a different story. So it is based on the intention of the husband, but we have known the intention of the husband from that context, which is the abandonment of his wife for 2 years and then sending her the divorce papers. So just a clarification.
Jazakallah. We have one more question from the brother, inshallah, and then we give Sheikh Salah Sawi the time to address us and elaborate on his point, inshallah. Go ahead.
Assalamu alaikum.
Make it very short, my dear brother.
The first question is short, the second one is
no, it's only one question.
Okay. All right, I'll ask the one that I think more practical for us. And that is in the context of the fact that we have refugees, we have widows, we have orphans, and we often criticize that Muslim communities don't step up to actually take them in their homes. So I'm going to give you a scenario of the husband and wife who are in their 20s. They wanted to do this, so they took on a 7-year-old boy just to be like the foster parent for him.
They did what?
They took on a little boy to be a foster parent for the child, for the orphan.
Oh.
And they're in their 20s when they took on this young boy, 7-year-old. 8 years later, now he's 15. And then the reality struck them that he's actually not a member of their household. Now the wife now has to wear hijab in his presence because he's now a grown boy. So the question is, so this is where the question breaks into two. For this couple, is she, because she's still having kids of her own, can she give him her breast milk to now make him a member of their household? And what will happen in a scenario where she's older and she's no longer producing breast milk? How do they make him a member of their household enough for her to now feel free in the presence of this boy they took on when he was only 7 years old?
Jazakallah khair.
رضاعة كبير. رضاعة كبير تبنوا طفله عنده 7 سنين وبعدين اكتشفوا عنده 15 سنة أنه هو ليس ابنه فما السبيل الآن إلى أنه يصير جزء منه.
توكل الله. أنا عندي واحدة تانية بعدين. توكل الله. تفضل. لا توكل الله. أنا عندي مسألة بعدك.
It is complicated. This is a complicated issue. So in general, when it comes to Rada' al-Kabir, so the Prophet ﷺ, it was reported that the Prophet ﷺ said, "La rada'a illa ma anbat al-lahm wa anshaz al-'azm." There is no rada'a except that which would basically produce flesh and grow bones and produce flesh. And the scholars have taken from this position that the rada'a that will cause mahramiyya, that the rada'a will make the murda, the wet nurse, non-marriageable, is the rada'a in the first 2 years of life. And the Hanafis said the first 26 months of life, or that's a position in the Hanafi madhab. I can be corrected. And in the Maliki madhab, there is a position also that it is up to 30 months. So we have 24 months, 26 months, and 30 months. And that's the position of the majority of scholars, and that's the position within the 4 madhahib. The Imam Ibn Hazm said that Rada' al-Kabir causes mahramiyya, which is to basically breastfeed like an older person, a person that's more than 2 years of age, does cause mahramiyya as well. And the proof that Imam Ibn Hazm cited was Salim Mawla Abi Hudhayfa, and how he was much older when the ayat of the adoption were revealed, and the Prophet ﷺ ordered his foster mother to breastfeed him. So then Imam Ibn Taymiyyah took a middle position. So Imam Ibn Hazm said this applies to all cases, all scenarios. He said that Rada' al-Kabir would apply to any case or any scenario. And Imam Ibn Taymiyyah took a middle position, and he said it would only apply. So it's not like the position of the 4 madhahib where it's limited to the 24, 26, or 30 months. And it is not the position of Imam Ibn Hazm, who said that it will always be applicable, and whenever she breastfeeds, that mahramiyya will ensue. he took a middle position, and he said, in circumstances like the circumstances of Salim, the rule will apply, because al-khususiyya will need to have, there needs to be a proof on khususiyya. That was the position of Aisha radiallahu anha, that who maybe the position of Aisha was closer to the position of Imam ibn Hazm, but Aisha also believed in that position, and many of the scholars of the Tabi'een had believed in that position as well. When the children from Bosnia arrived, and many of the scholars, Sheikh al-Qaradawi is one of them, they said, go ahead and breastfeed them, because you will otherwise leave them for the churches to take them and raise them as their own. So Muslim families were encouraged in this case to take those children in, and regardless of their age, to try to incorporate them within their families through Rada al-Kabir, through that what you call it, rukhsa, I would say, not necessarily hila, but rukhsa. And that's the position that I believe in. So whenever the circumstances are such that there will be significant harm not incorporating that child within that family, then we can use that position. Now, the Rada al-Kabir does not mean that he will basically breastfeed directly. He will have to latch on to her nipple. You extract the milk and you give it to them in a cup. That's the first thing that would make Rada al-Kabir a little bit more plausible, like a little bit more conceivable and acceptable. Okay? So the second thing is women can be given prolactin to produce that milk, even if they are not. And then we would come to a controversy, like another controversy, but, women can be given prolactin to produce that milk and then to extract that milk. And then the number of sucklings that are needed for this mahramiyya to happen is another issue, but that can be addressed. Finally, if she is completely unable, then the way to get around this is to have one of her family members, her sister, breastfeed him. She becomes a milk aunt, not a milk mother. She becomes a milk aunt. A milk aunt is good enough, because she is still mahram. But certainly it will not be as if she was a milk mother. Wallahu a'lam.
جزاكم الله خيرا. And now with Dr. Salah Issawi, inshallah.
بسم الله الحمد لله والصلاة والسلام على رسول الله. هذا السؤال متعة فقهية جاءتني من سائلة ما كنت أحسب أن امرأة تبلغ في عرض مسألة هذا المبلغ. تسأل عن حق المطلقة في نصف أموال زوجها التي تجددت له بعد الزواج، ثم تقول لماذا يفتي المشايخ بمنعه؟ أليس هذا من القوانين التي تملك الدولة تدبيرها أو فرضها لتدبير مصالح مواطنيها؟ ألسنا نقبل بقوانين هذه البلاد في التأمين وفي البنوك وعند المطالبة بالطلاق والنفقة والحضانة ونحوه؟ فلماذا نقبل بكل شيء ثم نرفض هذه وحدها؟ ثم لماذا لا تعتبرون تسجيل الزواج أمام المحاكم الأمريكية بمثابة موافقة من الزوج سلفا على قوانين الزواج السائدة في هذه البلاد، ومن بينها مقاسمة زوجه له لماله عند الطلاق، فيصبح هذا كالمشروط ابتداء في عقد الزواج. ثم أين تذهب المطلقة التي أفنت سحابة عمرها مع زوجها ثم طلقها في خريف العمر بعد أن أدركها الكبر وأدبرت عنها الحياة، وليس لها كافل ولا عائل في أرض المهجر وفي بلاد الغربة؟ ثم لماذا لا تفرقون بين بلاد المسلمين حيث توجد الأسرة والمجتمع المسلم وبلاد الغربة حيث ينعدم ذلك كله؟ ثم كيف تعتبرون مجرد بذل مؤخر الصداق إن وجد كاف لإنصاف المرأة وتأمين حقوقها عند الطلاق ربما يكون قد مضى عليه 30 عاما 40 عاما 50 عاما أو أكثر، فيصبح مبلغا زهيدا لا يكاد يفي في بعض الأحيان بوجبة طعام واحدة. ثم قالت: أفتونا ولا تفتنونا. والله ما أجمل هذا، أنا اقتنعت على فكرة.
I'm totally convinced.
أفتونا ولا تفتنونا. الجواب عن هذا بادئ ذي بدء، لابد من التأكيد على إنكار ما يتعرض له كثير من النساء من مظالم الأزواج وتجبرهم واستطالتهم على نسائهم. وما منا من أحد إلا وتختزن ذاكرته الكثير من هذه المواقف الأسيفة التي تدينها الشرائع السماوية والقوانين الوضعية على حد سواء، لا يصيغها عقل ولا يقبلها منطق. وإننا من أعماقنا ننكر هذه الاستطالات الظالمة ونشهد الله على بغضنا لها وعلى براءتنا ممن يتولون كبرها. ثم نقول: تقول السائلة الكريمة عن قانون مناصفة المطلقة لأموال مطلقها عند الطلاق، أليس هذا من القوانين التي تملك الدولة فرضها لتدبير مصالح مواطنيها؟ الجواب عن هذا أن حق الدولة في سن القوانين ليس مطلقا، إنما يكون في دائرة المباحات والعفو التشريعي، المنطقة التي تركتها الشريعة عفوا وأحالت فيها إلى الخبرة البشرية. أما ما حسمت الشريعة أمره وقطعت فيه بحكم معين فلا يملك حاكم ولا محكوم ولا دولة ولا مواطن إلا الإذعان والتسليم. فالحلال ما أحله الله ورسوله، والحرام ما حرمه الله ورسوله، والدين ما شرعه الله ورسوله. وما كان لمؤمن ولا مؤمنة إذا قضى الله ورسوله أمرا أن يكون لهم الخيرة من أمرهم، ومن يعص الله ورسوله فقد ضل ضلالا مبينا. هل تملك الدولة مثلا تغيير قواعد الميراث؟ هل تملك جعل الطلاق 5 بدلا من 3؟ ربنا قال الطلاق مرتان، نعمل قانون لا الطلاق 5. هل تملك الدولة هذا؟ هل تملك الدولة نقل صلاة الجمعة من يوم الجمعة إلى يوم السبت؟ ويوم السبت لا شك أنه أروح للمصلين، يوم أجازة والمواقف فارغة والناس ريلاكس، بدل ما هي مضغوطة في ساعة واحدة يوم الجمعة والحق ودلي واخبط. لا، ده احنا عندنا يوم كامل هادئ والناس تيجي راحتها من الساعة 10 المسجد وتتنفل وتقرأ قرآن وتنبسط. هل تملك الدولة هذا؟ إن القوانين في هذه البلاد أباحت الشذوذ الجنسي، وأباحت الزنا إذا كان عن تراض، أباحت القمار، أنشت له الكازينوهات، أباحت الخمر وغمرت بها الأسواق، أباحت لحم الخنزير، تفننت في تسويقه. فهل يقر مسلم بهذه التشريعات؟ ثم تقول السائلة: ألسنا نقبل بقوانين هذه البلاد في التأمين وفي البنوك؟ الجواب عن هذا أننا ننكر ما خالف الشرع من ذلك ونجتهد في دفعه أو في تقليل مفاسده ما استطعنا، ونسعى في التماس البدائل المشروعة. في عالم البنوك نجتهد في تجنب الربا ما استطعنا، فلا نفتح الحسابات الادخارية القائمة على الفوائد الربوية، بل نفتح الحسابات الجارية التي لا تدخل أصحابها في دائرة الربا، ثم نتخلص مما أقحم على حساباتنا من الربا بغير قصد منا بتوجيهه إلى المصارف العامة على سبيل التخلص. بالنسبة للغرامات التأخيرية التي تفرض على ما لا غنى عنه من الخدمات الحياتية كعقود إيجارات المنازل وعقود الهاتف والكهرباء، نجتهد في إسقاط هذه الشروط الربوية بالالتزام بالدفع في المواقيت والآجال المضروبة حتى لا نقع تحت طائلة هذه الشروط الربوية. في عالم تمويل شراء المنازل يجتهد الموفقون في التماس البدائل الشرعية بإقامة مؤسسات إسلامية أو بالتعامل مع فروع لمعاملات إسلامية داخل بنوك تقليدية. في عالم التأمين يقبل منه أهل الدين ما تحمل عليه الضرورات أو تدفع عليه الحاجات الماسة التي تنزل منزلتها، كالتأمين الطبي والتأمين الإجباري على السيارات والتأمين على المدارس، أو ما كان تابعا لعقد أصلي مشروع والخلاصة أنهم يتخيرون ويقبلون ويردون. أما ما تشير إليه من المطالبة بالطلاق والنفقة والحضانة أمام القضاء المدني، طبعا فيه تفصيل. الطلاق المدني لا بد منه لحل عقدة الزواج القانونية، وهو أمر يختلف عن العقدة الشرعية التي لا تحل إلا من خلال الزوج بالطلاق أو القضاء الشرعي بالتطليق أو الفسخ. أما المطالبة بالنفقة والحضانة فتلك حقوق شرعية اتفقت على أصلها الشرائع السماوية والقوانين الوضعية، فلا حرج في استدعاء سلطان القضاء الوضعي للإلزام بالحق الشرعي. لا حرج في استدعاء سلطان القضاء الوضعي للإلزام بالحق الشرعي. أما قولها لماذا لا تعتبرون تسجيل الزواج أمام المحاكم بمثابة موافقة من الزوج سلفا على كل قوانين الزواج السائدة في هذه البلاد، ومن بينها مقاسمة الزوجة لزوجها ما له عند الطلاق؟ هذا ليس بدقيق. التسجيل لا يعني بالضرورة الموافقة على منظومة القوانين الحاكمة للزواج في هذه البلاد، إنما هو لتحصيل مصالح راجحة ومشروعة لا سبيل إلى تحصيلها إلا بالتسجيل القانوني لعقد النكاح. ويبقى بعد ذلك أن منظومة القوانين السائدة يقبل منها ما وافق الشرع ويتحفظ على ما خلفه منها، سواء كانت في مجال الأسرة أم في غيرها. إن قوانين الأسرة في هذه البلاد تجعل من المخادنة والمساكنة غير الشرعية سبيلا إلى نشأة أسرة يتقرر لها من الحقوق الكومن ماري من جنس ما يتقرر للأسرة التي تتكون عن طريق الزواج. فهل يقبل مسلم بذلك؟ إن قوانين الأسرة تبيح زواج المثليين وتضفي عليه حماية قانونية. هل يقبل مسلم بزواج المثليين بمجرد تسجيله لعقد الزواج أمام القضاء المدني؟ إن القوانين هنا تسلب الزوج حقه في الطلاق. لو طلق زوجته 100 مرة بنية الطلاق لا تعتبر مطلقة، الذي يملك هذا فقط القاضي. فهل التسجيل يعني الموافقة على سلب حق الزوج في الطلاق الشرعي بالكلية وتخويله للقاضي بالكلية؟ ثم بعد هذا إن القانون الذي يقضي بتقاسم الزوجين أموالهما بالسوية ليس من القوانين الآمرة الملزمة التي لا يستطيع الزوجان مخالفتها، بل هو من القوانين المكملة التي يستطيع الطرفان الاتفاق على خلافها ولا تطبق إلا عند التنازع والتمسك بها من أحد الطرفين. وبقيت ملاحظتان: الأولى، القوانين التي تقضي بتقاسم أموال الزوجين هي نفسها تلزم الزوجين بالاشتراك في نفقة البيت على سواء طوال الحياة الزوجية، والشريعة لا تلزم المرأة بذلك، بل تجعل نفقتها على زوجها ولو كانت تملك المليارات ولو كان زوجها لا يملك إلا حد الكفاية. الثانية، أن تشوف المرأة إلى نصف أموال زوجها عند الطلاق كان وراء كثير من محن الطلاق وقصصه المأساوية، فعند أول عارض من فتنة تقفز المرأة إلى طلب الطلاق لتغنم نصف أموال مطلقها، بالإضافة إلى إنفاقه على أولاده منها، فتراها صفقة رابحة خيرا لها من البقاء في أسر الحياة الزوجية، فتتصدع أسر وتتمزق بيوتات، والموقف ينبغي أن يرى من جميع جوانبه. أما قول السائلة: أين تذهب المطلقة التي أفنت سحابة عمرها مع زوجها ثم طلقها في خريف العمر بعد أن مسها الكبر وأدبرت عنها الحياة إلى آخر ما قالت؟ سؤال مشروع، سؤال وجيه، نتكاتف في الإجابة عنه، نلتمس السبل المشروعة للتعامل معه، لكن ليس بتبديل الثوابت واستباحة المحرمات. وفيه عدة مداخل. المدخل الأول مؤخر الصداق، وقد يقع فيه الاتفاق على نسبة من أرباح المشروع الاستثماري الذي يديره الزوج إلى آخر المداخل الاشتراطية التي يمكن أن يتفق عليها. الأمر الثاني المتعة، وفي وجوبها لغير المطلقة قبل الدخول التي المسمى لها مهر خلاف فقهي، والقول بوجوبها مطلقا قول متجه، وبه قال كثير من السلف. وتقدير هذه المتعة هو المدخل الذي يدخل منه القضاء لمعالجة الآثار الناجمة عن الطلاق والتي تشير إليها السائلة. أما تعويض فرق التضخم فثمة قرار مجمعي من مجمع فقهاء الشريعة: الأصل أن ترد الديون بأمثالها لا بقيمها، إلا إذا أصاب العملة انهيار فاحش حاد، فهنا يصار إلى تعويض فرق التضخم. لا يقبل أن مؤخر صداق قبل 50 سنة كان يشتري بيتا واليوم يشتري سندويتش أو فنجان قهوة نقول هو ده مؤخر الصداق. ليس هذا هو التماثل، أن ترد بأمثالها. التماثل لا يتحقق بشكل الورقة ولا بطولها ولا بعرضها، إنما بالقوة الشرعية التي تتضمنها. هذه إطلالة عاجلة في تفصيلات يعني ضربت عنها الذكر صفحا لضيق الوقت. بارك الله فيكم، شكر الله لكم.
جزاكم الله خيرا، نفع الله بكم، تقبل الله منكم.
نفع شيخنا، نفع شيخنا،
لبيك
حاضر شيخنا، نفع.
جزاكم الله خيرا. Inshallah, now we have lunch break and until 1:15, and from 1:30 to 1:45 we have Salat al-Dhuhr and Al-Asr together combined 2 and